Be ready. 3, 2, 1, start. The assumption of the appellants that the actual future pay revisions should be taken into account for the purpose of calculating the income is not sound, as against the contention of the appellants that if the deceased had been alive, he would have earned the benefit of revised pay scales. It is equally possible that if he had not died in the accident, he might have died on account of ill health or other accident, or lost the employment, or met some other calamity or disadvantage. The imponderables in life are too many. Another significant aspect is the non existence of such evidence at the time of accident. In this case, the accident and death occurred in the year 1988. The award was made by the tribunal in the year 1993. The High Court decided the appeal in 2007 para. The pendency of the claim proceedings and appeal for nearly 2 decades is a fortuitous circumstance, and that will not entitle the appellants to rely upon the two pay revisions which took place in the course of the said 2 decades. If the claim petition filed in 1988 had been disposed of in the year 1988 to 89 itself, and if the appeal had been decided by the High Court in the year 1989 to 90, then obviously the compensation would have been decided only with reference to the scale of pay applicable at the time of death, and not with reference to any future revision in pay scales. If the contention urged by the claimants is accepted, it would lead to the following situation. The claimants only could rely upon the pay scales in force at the time of the accident if they are prompt in conducting the case. But if they delay the proceedings, they can rely upon the revised higher pay scales that may come into effect during such pendency. Surely, promptness can be punished in this manner. We therefore reject the contention that the revisions in pay scale subsequent to the death and before the final hearing should be taken note of for the purpose of determining the income for calculating the compensation para. The appellants next contended that, having regard to the fact that the family of deceased consisted of 8 members, including himself, and as the entire family was dependent on him, the deduction on account of personal and living expenses of the deceased should be neither the standard one third nor on fourth as assessed by the High Court, but on eighth. We agree with the contention that the deduction on account of personal living expenses cannot be at a fixed one third in all cases bracket unless the calculation is under section 163A read with section 2nd schedule to the MV Act bracket close. The percentage of deduction on account personal and living expenses can certainly vary with reference to the number of dependent members in the family, but as noticed earlier, the personal living expenses of the deceased need not exactly correspond to the number of dependents. As an earning member, the deceased would have spent more on himself than the other members of the family, apart from the fact that he would have incurred expenditure on traveling, oblique transportation, and other needs. Therefore, we are of the view that interest of justice would be met if one fifth is deducted as the personal and living expenses of the deceased. Stop.